Hello, welcome to EPG Pathshala, the course Legal Literacy. I am Maruk Edendwala, a practicing lawyer who is going to take some of the modules on legal literacy. This is module 7. It deals with public interest litigation. I'm going to cover public interest litigation in two parts. This is the first part. In the first part, we are going to deal with the concept of public interest litigation. What is the difference between public interest litigation and regular litigation? What should a social worker who wants to facilitate the filing of a public litigation keep in mind? Public interest litigation, which is commonly called PIL, was conceptualized by the Supreme Court in the late 1970s, early 1980s. You will recall that a person or group can approach the Supreme Court and High Court if their fundamental rights are violated under Article 32 or 226 respectively. But the Supreme Court noticed that despite there being a mechanism to approach the Supreme Court for redressal in case of violation of fundamental rights, people were not doing so. Why is that? One, because people were not aware of their fundamental rights or their basic rights, and they continued to suffer the violation. Secondly, even if they knew that the fundamental rights or most basic rights were being violated, they did not know what to do. Thirdly, the courts were too remote, geographically remote and inaccessible because of monetary constraints or need for legal representation. I would like to tell you that two judges, Justice Krishna Iyer and Justice P.N. Bhagwati, were the co-founders of public interest litigation. The Fertilizer Corporation Kamgar Union case was a case where both Justice P.N. Bhagwati and Justice Krishna Iyer were sitting on the 5-judge bench. In this matter, the workers' union challenged before the court the sale by the management of plants and equipment on the ground that it affected the fundamental right, that is right to occupation, and also that the procedure followed was arbitrary. Though this judgment dismissed the claim of the petitioner, it has laid down very important things with regards to change in this concept of locus standi. What do we understand by locus standi? Locus standi is the authority or locus or standing of a person to approach the court. In regular writ petitions, it is the person who has suffered injury who approaches the court for relief. But in public interest litigation, any third party may approach the court on behalf of an individual or group whose fundamental rights are being violated. Hence, public interest litigation is merely broadening of the concept of locus standi. Please read this slide carefully. What do we mean by ubi just, ibi remedium? It means that for every wrong, the law provides a remedy. Hence, the Supreme Court felt that they should think of an innovative method to ensure that every person attains justice. And that is basically the main intention of the Constitution. Now we are going to look at what should a social worker keep in mind when he or she is facilitating the filing of a public interest litigation? The first thing is the selection of a court. A public interest litigation may be filed in the High Court or the Supreme Court. Secondly, the petitioner. Who should the petitioner be? Should it be an individual, a group of persons, or an organization? Third, the proper identification of respondents. The state agencies responsible for the violation and a private party, if any, should be added as a respondent. 4. gathering of facts. All the material facts should be brought before the court. 5. The law. The PIL must contain the fundamental rights that is violated and any other provision of a domestic law, as also provisions of the international covenants or conventions. Drafting of prayers. These are the orders sought from the court. Now we shall in detail look at each of these points. Selection of the court, Supreme Court or High Court. The court will be selected depending upon the subject matter of the case. If the subject matter is such that it applies to the entire country, then you should file a PIL before a Supreme Court. But if the subject matter is localized, then you may file the PIL before the High Court. For example, if you are challenging the constitutional validity of a central government law which is applicable throughout the country, then you may file the PIL at the Supreme Court. But if you are challenging, for example, a forced eviction or a demolition that is proposed to take place or in a particular localized area, then you may file the PIL before the High Court. But my suggestion is that it is preferable to file a PIL before the High Court. 1, because if you get an adverse order, then you have an opportunity to challenge the order before the Supreme Court or maybe before another High Court. Also, the High Court is more familiar with the local issue as it is regularly being covered in the press. The petitioner. The petitioner could be an individual or organization. You may recall that I mentioned that the petitioner is a third party, a person in a PIL. That is, a person whose fundamental rights are not violated. He is approaching the court on behalf of an individual or a group of persons whose fundamental rights have been violated. So it is very important to select the correct petitioner. The petitioner could be an expert on this issue, or it could be a person who is working with those whose fundamental rights have been violated, or he could have gathered detailed information regarding the fundamental rights violation. My suggestion is that it is preferable if the petitioner is an organization. 1, because he would better be able to gather the relevant facts and to monitor the compliance of the orders passed. An individual may not have the capacity to do so. 2, it is not as if a public interest litigation is going to get over in a week or a month or even a year. Sometimes an individual may lose interest if the matter is not disposed expeditiously. 3, an individual may get pressurized. You must remember that in a public interest litigation, the respondent is a state agency, a very powerful body, who may pressurize an individual into withdrawing the PIL. If it is an organization, the organization is the face of the PIL and an individual is not targeted. So the reason to have an organization is it ensures continuity. Respondents. It is very important to identify the proper respondent. That is the state agency who is responsible for having committed the fundamental rights violation. You should mention the state agency or even the name of an individual person who is holding a state office. Though a state agency is the primary respondent in a public interest litigation, a private party too may be inserted as a respondent. For example, if an industrial unit owned by a private company is discharging effluents into the stream, which is causing the water to turn hazardous, the petitioner may have written to the Pollution Control Board, but if the Pollution Control Board fails to take appropriate action, then a PIL may be filed against the Pollution Control Board, the Ministry of Environment and Forest, as also the private party who owns the industrial unit, because it is the private party who will also have a role in compliance of the order. Gathering of facts. The facts gathered and portrayed in the PIL must convey and describe the situation on the ground. It is very important for the petitioner to gather all the facts and put them before the court. The facts must denote the violation of fundamental rights. You should annex to the petition all documents that supports the case you have made out. It may be a newspaper report or it may be a fact-finding report. The law. The public interest litigation must contain the law in detail, the fundamental rights that have been violated, or any other provisions of statute which has been violated. The portion regarding the law should also contain provisions of the international covenants and conventions which India has ratified or acceded to. Because we cannot allow the government of India to make promises on the international platform and come back to the domestic sphere and violate them. So it's important that the government of India is made to commit to the provisions of the covenants and conventions. Prayers. The prayers are an extremely important part of a petition. The prayers denote the reliefs and the orders that you want from the court. All the prayers should be supported by the facts which are contained in the PIL. While drafting the prayers, it is very important that the petitioner consults with those whose fundamental rights have been violated. It is important to know what redressal they want from the courts. What are their demands? The orders obtained from the court should provide relief to those whose rights are contravened. Orders are not for mere academic values. They should ensure that the peoples whose fundamental rights are violated get some relief. Follow-up. It would be very naive if the petitioner believes that orders passed by the court will be followed by the state agencies. The state agencies will try and not implement these orders. Hence, the petitioner will have to follow up with the state agencies to ensure that the orders passed are reflected on the ground and the people enjoy the orders passed. Another problem is that an adverse order may be challenged by the state agency before the Supreme Court. Hence, the petitioner will have to litigate the matter now in the Supreme Court. So, the petitioner should have some contacts in Delhi who will be able to assist him in doing so. The respondents, it's not as if the respondents disobey the order because they are not able to comply with the same. It is willful disobedience. If a state agency willfully disobeys an order, then the petitioner may file contempt of court proceedings. Contempt proceedings are taken out when the petitioner believes that the respondent is able to comply with the order but has willfully disobeyed the same on some pretext or the other. It is important that the public interest litigation is taken to its logical end. It is the responsibility of the petitioner, both moral and legal, to ensure that benefit is accrued to those whose fundamental rights are violated. Sometimes a petitioner is not able to gather all the facts for several reasons, which could be: 1, the magnitude of the problem; 2, he has no access to this material. The Supreme Court has then innovated appointment of commissioners, because the Supreme Court believes that a petitioner in a PIL who is a public-spirited person whose fundamental rights have not been violated should not be made or forced to undergo great difficulty in collecting the facts. Hence, the Supreme Court or the High Court appoints a commissioner. A commissioner could be an officer of a court, such as a registrar. It could be a lawyer. It could be an academic. It could be an organization who will have to visit the sites and prepare a report which is submitted to the court. On the basis of the report, the court will find out what the actual facts are at the grassroots level. Also, it will be an impartial representation of the facts. Bandhwa Mukti Morcha versus Union of India was one case where the Supreme Court appointed a commissioner and spoke about the need of the commissioner. It believes that the Supreme Court should be proactive towards ensuring that people attain their social justice, and hence people should be provided with the opportunity to approach the courts. If they are not able to do so, then a third party who is a public-spirited individual should be allowed the opportunity to approach the court. So the only difference between a regular petition and a PIL is the difference in the concept of locus standi. In a PIL, a third party who is not affected by violation of fundamental rights may represent the cause of those whose fundamental rights are violated. In this portion of the Fertilizer Corporation Kamgar Union judgment, the Supreme Court states, the question whether a person has the locus to file a proceeding depends mostly on and often on whether he possesses a legal right and that right is violated. Let us stop here. What does the first sentence denote? It denotes that in a regular petition, the Supreme Court says only the person whose rights are violated or to whom some injury or damage is caused may approach the courts. Next, the Supreme Court goes on to say, but in an appropriate case, it may become necessary in the changing awareness of legal rights and social obligations to take a broader view of the question of locus. Here what the Supreme Court is saying, what do they mean by in an appropriate case? An appropriate case deals with the weaker sections of society or the downtrodden whose fundamental rights are being violated on a daily basis, but who does not have the capacity to approach the Supreme Court or the High Court. So in such cases, the court has to innovate a new method. Now, what is this new method? And what is locus? Locus, as I earlier mentioned, is the standing or authority of a person to file a case. And the judgment goes on to say that it may be filed under Article 226 or under Article 32 of the Constitution. The court has also said that, in simple terms, locus standi must be liberalized to meet the challenges of the times. Law is dynamic. It has to change depending upon the situation. The court cannot be a silent spectator knowing that people are not able to approach the courts for remedying their constitutional rights violation. In fact, it goes on to say, UB just, EB remedium must be enlarged to embrace all interests of public-minded citizens or organizations with serious concern for conservation of public resources and the direction and correction of public power so as to promote justice in its truant facets. We must remember that one of the tenets of law is that for every law, the law provides a remedy. Hence, if no remedy is provided, the court will have to innovate a remedy. At this stage, it's also important to recall that a judgment of the Supreme Court and High Court becomes the law of the land. Of the Supreme Court is applicable throughout the country, and of the High Court within the territorial jurisdiction of that High Court. Let us see what the Supreme Court had to say about the Bandhwa Mukti Morcha case. The facts of the Bandhwa Mukti Morcha case. Bandhwa Mukti Morcha was an organization which worked for release of bonded labor. They brought to the notice of the Supreme Court the fact that several people were working in the stone quarrying in Faridabad district of Haryana state as bonded labor. Now, this is what the Supreme Court had to say in this case regarding the appointment of a commissioner. Now it is obvious that the poor and the disadvantaged cannot possibly produce relevant material before the court in support of their case. So the first thing which this judgment acknowledges is that gathering of facts is very difficult for the weaker sections of society who are faced with the question of survival on a day-to-day basis. It is equally difficult where an action is brought on their behalf by a citizen acting pro bono publico. It would almost be impossible for him to gather the relevant material and place it before the court. The Supreme Court has recognized that a third party who has approached the court has approached it out of his concern for those whose fundamental rights are violated. He too cannot be put under difficulty to gather facts which are not easily accessible. Then what is to be done in such case? What is the Supreme Court to do in such a case? Would the Supreme Court not be failing in discharge of its constitutional duty of enforcing a fundamental right if it refuses to intervene? So here what it has said, that the Supreme Court is obligated, mandated to take up the case of fundamental rights violation. But should they just let the case go because the material facts are not before them, or should the Supreme Court act in a more proactive manner? The underprivileged, because the people belonging to the underprivileged segment of society or a public-spirited citizen espousing his cause is unable to produce the relevant material before the court. If the Supreme Court were to adopt a passive approach and decline to intervene in such a case because relevant material has not been produced before it by the party seeking its intervention, the fundamental rights would remain merely a teasing illusion so far as the poor and disadvantaged sections of the community are concerned. At this stage, we must also remember Article 39A of the Constitution, a directive principle, which says that everybody should have an opportunity for legal justice. In fact, even the weaker sections and the downtrodden should have this opportunity. Hence, the Supreme Court has innovated public interest litigation. It cannot be that merely because a person cannot approach the court due to some disability, he does not have the opportunity to justice. Hence, a third party may litigate the cause of the person whose fundamental rights are violated. And the Supreme Court has correctly said that the third party should not be put under great difficulty. Hence, a commissioner could be appointed to collect the facts. For example, if a public interest litigation has been filed with regards to rehabilitating those whose homes were demolished during an earthquake. If the area which was affected is very vast, the petitioner resides in a particular village or knows of people residing in a particular village, he may not be able to travel the entire area which was adversely affected by the earthquake. In such case, the High Court or the Supreme Court may appoint an officer of the court to visit the different areas and to submit a report. This will enable a more holistic relief being provided to the victims of the earthquake. In conclusion, I would like to say that this module deals with public interest litigation and, more importantly, what do we understand by expansion of the concept of locus standi. The Supreme Court has been very clear that it is their mandate to ensure that people enjoy their fundamental rights and they cannot turn a blind eye to such violation. Hence, if the person is not able to approach the court, some other method has to be adopted. Thank you.